It has been answered over and over and over. 45 of 48 counts. We do not hold up investigations for anything. You are disparaging the reputation of the men and women in that office who have worked very hard to get to the result that justice was served and a monster was taken off the street. They are not going to hold it up for anything. It takes a long time to develop these cases. They have the experience, I have the experience. I've handled cases like this. And to continue to ask that question, quite honestly, is in my mind out of line. These men and women did their job, and I have done my job. People are going to criticize everything that's been done. I will go back to number one fact that we have taken a monster off the street, 45 of 48 counts.
Even a highly successful final result does not mean that the investigation itself was a complete success, particularly when a serial child molester was left uncharged for so long. During the over 35 months between the beginning of the investigation in November 2008 and the filing of charges against Sandusky in November 2011.
But what do these clues say about the sudden disappearance of the district attorney who left them behind?
It's baffling, it's confusing, and perplexing. It's all of those things.
His name is Ray Guicar. When he vanished in 2005, it was a big story.
A prosecutor in Pennsylvania who vanished on Friday is still missing.
Now, Ray's story is linked to an even bigger one.
Stunning allegations of sexual child abuse.
One of the most storied names in college sports is enveloped in scandal.
Because 7 years before he went missing, Ray Guicar decided not to prosecute Jerry Sandusky for the first known allegation of child sex abuse against him. Now, some are asking whether that Sandusky case had anything to do with the DA's disappearance.
For anyone to think there is no relationship is the epitome of naivety.
No comment on that today from Second Mile, nor was there any comment on a report in the New York Times that several years of organization records were missing and possibly stolen. Unnamed investigators telling the Times that the missing files may make it tough to determine whether Sandusky used charity money to recruit, to groom, or travel with possible victims. No comment either on a separate report. NBC News citing a senior law enforcement source saying the FBI may be looking to open its own investigation into whether Sandusky broke federal law, whether he transported a minor across state lines to commit child abuse. One boy, identified in the grand jury report as victim number 4, says Sandusky repeatedly abused him, including at out-of-state college bowl games. Then there's a late Center County District Attorney Ray Guicar, who investigated alleged victim 6's allegations back in 1998 and decided not to prosecute. Well, it turns out there is no paperwork or decision memo laying out the reasons why he declined to prosecute. In fact, we've learned the DA's office has no files on the case.
Child abuse allegations deemed unfounded must be expunged within a certain period of time. Now, that's apparently what happened with the 1998 allegations. Those allegations were referred to the Department of Public Welfare. They were considered by the district attorney at the time in Center County. The case was not charged at the time. Again, that's a subject beyond the scope of this report. But as a result of the case not being charged, then the record of those allegations had to be expunged from child line records. Right? And as a result, when the new allegations against Sandusky came in 2008 and 2009, a check of those records would have revealed no prior allegations. And so as a result of that, investigators, one of the reasons why investigators didn't learn about those 1998 allegations until later. There was institutional knowledge within the Center County DA's office about that 1998 investigation.
Former DA Madeira has a brother-in-law adopted by Jerry Sandusky. So when the molestation charges first came to his office in 2009, he saw that they were serious and turned the file over to the state attorney general, claiming conflict of interest.
So we get to 2009, the case is being transferred from the Center County DA's office to the Office of Attorney General, and the fact that those 98 allegations existed was not passed on. Nobody at the Attorney General's office, nobody at Pennsylvania State Police was told about those earlier allegations.
Law enforcement, Attorney General Tom Corbett and Congressman Glenn Thompson agree. On Election Day, Center County needs to re-elect proven crime fighter Michael Madera, District Attorney.
Investigative steps that were considered but not taken during this time, such as searching Sandusky's residence and going to the local Children and Youth Agency and asking whether there were other allegations against Sandusky. Those are things considered in 2009 but not undertaken. As one expert put it in a book written before Sandusky was charged, I'm going to quote, "The major law enforcement problem with the use of search warrants in child sexual victimization cases is that they are not obtained soon enough." Again, that's not written about Sandusky, that's written generally about these sorts of cases. Read that again. "The major law enforcement problem with the use of search warrants in child sexual victimization cases is that they are not obtained soon enough." And that was certainly the case in the Sandusky investigation. The search of Sandusky's residence did not occur until June 2011. Right? That's more than 2 years after the case got to the Office of Attorney General, and as you'll see from the report, it's more than 18 months after searching was suggested by an investigator in the case. Again, more than 2 years after the case came in, more than 18 months after an investigator suggested conducting the search. And when the search finally did happen, it uncovered unquestionably valuable evidence, including photographs of Sandusky victims and lists of second-mile campers with asterisks next to some of their names, asterisks that later turned out to line up with people that Sandusky had victimized. Had the search been conducted in 2009 or 2010, investigators could have used those photographs and could have used the names to find victims much earlier than they did. Now, why did the search not happen earlier? There are a number of reasons given, one of which was to keep the investigation secret. Another was a concern about the lack of probable cause or staleness. But the experts tell us that serial child molesters regularly maintain, in terms of staleness, which is the idea that months after a crime has occurred, it may be less likely that evidence of that crime is going to still exist at the location in question. So was it likely? And victim one's, I knew I was going to do that. Victim one's allegations were about conduct that ended in the fall of 2008. Right? The case doesn't come to the Office of Attorney General until March of 2009. So a number of months have passed. Is it now too late to conduct a search? Is the evidence stale? And the answer to that is no. The simple answer to that is no. And in fact, the evidence was not much fresher in 2011 than it was back in 2009. And that's because experts tell us that serial child molesters regularly maintain valuable evidence about their crimes, including items as simple as ordinary photographs of their victims, which is something that Sandusky did. Moreover, victim one described being abused in Sandusky's basement at his home and provided investigators with valuable and significant details about the layout of the home. If for no other reason, a search early on could have provided very useful corroboration for victim one's story, which is exactly what some people were saying they needed before they could charge, and yet the search didn't happen.
Why is one child rape victim or alleged victim not enough?
It could be enough. And if it were a non-celebrity, yeah, maybe. But the best thing you can do when you're talking about a child saying that an adult is doing something that is this horrific to me, and he's a coach, you want to corroborate it. You build those cases as well as you can.
Search warrants are properly issued every day based on the word of a single victim. If the idea that a single victim wasn't enough to get probable cause, that would be astonishing. Right? It's one thing to say that a single victim might not be enough to support a conviction. Right? Again, we talked about that. That's something that reasonable minds might differ about. But it is quite another thing, I think quite wrong, to suggest that it's not enough for a search. Significant factors, sort of overarching factor as to why the investigation took as long as it did, was the failure to take certain steps earlier in the investigation that proved very valuable later on. Okay, what were those steps? The most significant of those steps, any one of which could have been taken in 2009 or 2010, were searching Sandusky's home, asking the local police about earlier investigations involving Sandusky. That's how they ended up getting the 1998 allegations or finding out about them, and questioning the local Children and Youth Service and the Second Mile about Sandusky as well. Of course, had the plan been to charge Sandusky right away, which other prosecutors might reasonably have pursued, right, there would have been little need for the grand jury. But that was not the plan. That was not the plan. The plan was not to charge right away. The plan was to investigate, and so the decision was made to use the grand jury. Both Eschbach and her supervisors, all the way up to the Attorney General at the time, they all believed that the advantages of the grand jury, mostly in terms of subpoena power, requirement of oath, secrecy of the investigation, that they all supported its use to investigate Sandusky.
A thorough investigation takes time. It takes time to find witnesses.
The real problem is really quite the opposite at some level, and that is for long stretches of time, before the investigation was ramped up in 2011, the resources of the grand jury were barely used at all. In 2010, for example, from the beginning of January through the end of October, okay, right before the McQueary tip, the grand jury issued no subpoenas for testimony, and it issued only one for records. On November 3rd, the Center County District Attorney, Stacey Parks Miller, received an email saying that investigators should talk to Mike McQueary, that he had information that was relevant to the investigation. In contrast, you look at 2011, for that same time period, January to October 2011, the grand jury issued more than 50 subpoenas for testimony and more than 50 subpoenas for records. Unfortunately, during that time, the investigation was at a complete standstill. During those 5 months, March to August 2010, no witnesses were interviewed, no subpoenas were issued. And for the next 2+ months after that, no one new was interviewed, and the investigation did not succeed in identifying any new victims. So we get to the early November 2010, and as Eschbach put it when she was interviewed, the investigation was dead in the water at that time. Had the investigators been more aggressive, and we'll talk about this in a couple minutes, had they taken the investigative steps that they could have taken in 2009 and in 2010 that they didn't take until 2011, they almost certainly would have had much more evidence by the summer of 2010, and so that decision would have been a lot easier. That decision, the decision in 2010 not to charge, based on the evidence available at the time, was made by then Attorney General Corbett.
What's your message? When you were the Attorney General, not to press charges against Sandusky in that initial.
Say that again?
When you were Attorney General and the case from Clinton County came to your desk, can you talk about why you decided to look at a more broad case instead of charging him on that one right away?
Well, no, I'm not going to comment on that, but I would comment about it. And I think you all need to understand how investigations work. You get information, you get a case referred to you, you begin to take a look at a case, and I'm not speaking of this case, and you develop witnesses. Harold, you know this. You develop witnesses, and you go from one witness to the next, and you continue to build a case. Oftentimes it leads you to places you never would have imagined that it would lead you to. So, I mean, oftentimes it takes quite a bit of time.
The decision, again, reasonable minds can differ about that decision whether to charge or not, but during the time that that they were considering the decision and for several months thereafter, there really was no concerted effort to go find more victims, and that's puzzling in retrospect.
This report found no direct evidence, no email, no confession, no statement from anybody indicating that they were told to slow this down because of politics. Because this was an administrative review, not a criminal investigation, we lacked subpoena power. This report also shows long periods of inexcusable, and by inexcusable I mean that even the parties involved couldn't offer an excuse for the delays, and delays that quite honestly are unfathomable to most of us. Why those delays took place, we don't know the answer to that. We don't know what was in their head.
And I was in contact with them on a regular basis. How's it coming? How's it coming? Keep moving, pushing. You tell me when you're ready.
There's nothing in the documentary record or witness interviews to suggest that then Attorney General Corbett gave any instructions at all about how to conduct the investigation of Sandusky. He did obviously make the decision not to charge in August, but other than that, at an operational level, he said and others said that he wasn't making those decisions.
This report details missteps, miscommunication, missed opportunities. Who should be held accountable for that?
That's a good question. it appears as that the line prosecutor from the very beginning wanted, and as well as the agent and the troopers, wanted to conduct a search warrant, which was never done. It was declined, that it was rejected that they would be able to do a search warrant. It was the decision of the group to use a grand jury, and that's prosecutorial discretion. Some people would go that route. Some people wouldn't. But once you go that route, you have to use the tools of the grand jury that were offered. And as the report indicates, through long periods of 2009 and 2010, the grand jury resources were not used fully, as opposed to what happened in 2011. So it appears that the leadership of OAG, who was making the decisions, not the line prosecutor, had a real lack of urgency in taking Sandusky off of the streets, and also made some tactical errors that could have brought him off of the streets sooner.
You say the leadership, do you mean Tom Corbett?
Well, the leadership consisted of the chief of the criminal unit at the time, the chief of the criminal division of the time, the first deputy at the time, and the attorney general at the time.
What happened is things that should have happened, or there are two sets of problems, right? There are investigative steps that were not taken until 2011. That could have been taken in 2009. And I think for some of those steps, maybe there was a rationale for that. I mean, one of the rationales offered was, well, we didn't want to go to Penn State or to the local police department or Center County CYS, because if we did, then Penn State would find out about the investigation, and that might be bad. But on the other hand, there were decisions that were made that I think reasonable minds shouldn't differ about, like, for example, searching Sandusky's house. That could have happened in 2009. Should have happened in 2009. So there are those sorts of decisions. There are also delays. Again, that March to August 2010 time period, not only was it a long time coming, the answer, but during that time, nobody was doing any investigation.
There was also tactical errors that were made that could have moved this case 2 years sooner, at least 2 years sooner than it was. And those are inexplainable. The 5-month delay between March of 2010 until November of 2010 as to why it sat on someone, the presentment sat on someone's desk and there was no answer given. We don't know why that happened.
In terms of consequences, the longer somebody like Jerry Sandusky is out and about, unouted to the public, the more risk he poses to the community.
Did it weigh on your mind that there might have been more victims out there as the
Absolutely. You mean that he could be victimizing? Yeah, I was worried about it. But at the same time, I believe he had to know we were looking at him at some point in time. And so if you know that they're looking at you, you kind of back away.
Experience tells us, and the research tells us, that serial child molesters are significantly more likely than other offenders to continue their behavior, right? Even if they know that they're being investigated. We haven't charged yet, but the target knows we're investigating him, so he's unlikely to be continuing to offend. That does not necessarily apply when we're talking about these preferential serial child molesters. One other point about that 2010 decision point, senior leadership at the Office of Attorney General, they had a line prosecutor who wanted to file charges. Her bosses, though, up the chain of command, they all believed that there were likely more victims out there. That was a premise from very early on, that this was not a single incident involving victim one, but that Sandusky hadn't fit the profile of somebody who was likely to have offended on many occasions with many victims.
But it was a calculated risk, not one that you really easily want to take.
In the course of your investigation, did you become aware of any new victims who were alleging sexual abuse by Jerry Sandusky that happened after the case was transferred to the Office of Attorney General?
Yes, we do have 2 individuals who indicated that they were abused by Sandusky both in the fall of 2009.
Brad? Well, could you elaborate on that? I mean, what happened? Did you investigate those cases then?
Those cases were already known before I took office.
Did he reoffend while the investigation was going on? Is that what you've now said?
The Office of Attorney General received the case in March of 2009, and 2 individuals indicated that they were abused by Sandusky sexually in the fall of 2009.
That figured in the prosecution?
They're not.
We must keep in mind that when it comes to the safety of children,
there can be no margin for error, no hesitation to act.
There's a question as to whether anybody indicated that they were abused by Sandusky after the Office of Attorney General received the referral in March of 2009 and while Sandusky was walking the streets. The answer to that question is 2 individuals have indicated that they were abused by Sandusky in the fall of 2009.
About the 2 victims that indicated they were abused in the fall of 2009, I just wanted to ask you, so was there any investigation done as to the credibility of those persons' allegations, and do you believe they're founded? Do you believe they were credible to the point where law enforcement could have pursued them? Because the reason I ask that is I remember that there was one story about somebody that came forward and it was indicated that it may not have been founded. And so can you tell me what your thoughts are about the credibility of those 2 allegations?
I'm not going to discuss the credibility of sexual abuse victims until they are found by a jury to be uncredible or incredible. The victims of sexual assault, when they tell us they're the victims of sexual assault, and unless we have anything to the contrary, we believe them.
Is it conceivable to you that if the investigation had been executed at whatever level in a different way, that the 2 victims who say that they were abused or assaulted, in the fall of 2009, that either or both of those might not have happened?
Lots of choices got made here. One of the choices that got made really both by the 2 district attorneys who had the case briefly and by the Office of Attorney General right at the beginning in March 2009, the choice was made that we're going to investigate further before we bring charges. Had that decision not been made, had he been charged right at the outset, then there would have been a greater level of public awareness that he was a child molester. Now he was released on bail, as it turned out, in 2010. But sure, if the case had been charged sooner, the people who were involved in the investigation, the investigators who spoke to us, and the prosecutors, all of whom spoke to us, were aware of the risk. They were aware that he might be continuing to offend, and they hoped that the fact that he was aware of the investigation would make that less likely. And they concluded that the risk of a failed prosecution was greater than the risk posed by that. So they did have those discussions.
Your actions speak much louder than your words.
Madam Attorney General, do you believe those victims who come forward in the fall of 2009 would not have been abused had this investigation gone more quickly?
If different steps were taken, if the course of action was taken that the search warrant would have been issued and executed, which could have been executed under seal right away, based upon the statements of victim 1, then they would have found the corroborating evidence that they felt necessary for victim 1. They also would have found the additional victims that they also felt necessary, would have made the case stronger. If that had happened, then Sandusky would have been charged earlier, no doubt. Now, you're going to have prosecutors coming out of the woodwork saying, well, we feel that the grand jury was the better choice. Okay, if you make that choice that the grand jury is the better choice and you go that route, then use the tools of the grand jury. You have to use all the tools necessary, because there's a real difference between making sure that the streets are safe from a sexual offender and building a winnable case. You have to make that decision. Different prosecutors make different decisions. I would have made a different decision.
And so the 2 people who come forward in the fall would not have been abused had they made the decision that you're now advocating.
Logically speaking, if different tactics were taken and a different route was chosen, and Sandusky was in jail with bail, by the way, if bail hadn't been that he was released on, with a cash amount, if he was in jail, of course, this factual report indicates that there are long periods of time where nothing happened. There are long periods of delays that we can't explain. This report also indicates factually that key investigative steps were not taken early on. For example, the search warrant. And because of that, the case took longer than it could have or should have. What this report also indicates, this factual, unbiased report indicates that the reasons put forth, Mr. Moulton's reasons put forth of, well, why did they take these certain tactics? Why did they use the grand jury? Why did they not issue the search warrant? Indicates that there wasn't that sense of urgency to get Sandusky off of the streets that other prosecutors may have had, and therefore chosen different courses of action.
We're going to take 2 more questions.
Sorry, I can't hear
you. We'll be available all day. All yell.
With the Attorney General,
I would have done it. I would have issued a search warrant. Whether that's, hold on one second. So the question was, does the buck stop with the Attorney General? The buck always stops with the leader.
We need to protect children. We need to act. Unfortunately, in my career, particularly as Attorney General, I've seen many instances where people who have power believe that they're beyond the law.
With respect to the victims that she's mentioned, the people who allege that they were victimized in the fall of 2009, I think my understanding of the facts is that those are folks who, during the course of the investigation, and I think not before 2011, investigators learned about. So I don't think there's no suggestion that folks knew in the fall of 2009 that these additional victims existed. They believed there were additional victims, but they didn't come to light until 2011. The investigation, as far as I'm aware, the investigation was not aware of any additional victim besides victim 1 until the Mike McQuarrie. That was the first one.
You still believe it was politics?
I've always said from the very beginning, and I am a prosecutor through and through, and in a closing argument, it doesn't matter what our personal opinion is. I rely upon the facts, and the facts is there was no direct evidence, but there are questions of inexcusable delays. Why those delays took place, we don't know. There are questions of tactical errors that were made. Why were those tactical errors made? We don't know. And in that instance, we have to put it out to the public, and just like a jury, we have to say, you need to base your opinion upon the facts, and you need to rely upon your own personal experiences. There are serious questions as to why those delays occurred. Why was there inactivity or virtual inactivity for almost 18 months? Why wasn't a search warrant issued in the beginning? Why did it sit on someone's desk? And for that, we can't answer.
We need to identify these victims of sexual abuse. We need to find them. We need to help them. They are our children.
There have also been a lot of questions about the Second Mile, the charity that Mr. Sandusky acquired, and how they had handled this matter. Were you familiar with the Second Mile, and do you have any concerns about how they handled the information that they had about Mr. Sandusky?
I am familiar with the Second Mile. I believe there will be inquiry as to, first off, what information they had. Since the Attorney General has not done anything there yet in that respect, and charities do come under the purview of the Attorney General in a different section of the Attorney General's office, I make that as an observation, not as a conclusion. I think that relationships between outside charities and the university certainly have to be looked at, and I'm sure that that committee will look at it.
Do you have concerns about the way the charity officials handled this matter?
I don't know how they handled it, so I can't say that I have concerns. That has to be determined what, if anything, they knew about this. I have not seen, and I don't think any of you have seen, anything that anybody other than one individual connected with the charity. One individual had any knowledge.
And also the general counsel of the university was also the general counsel for the charity.
Again, I need to know what the charity, what the board members knew. And I think that's a determination that people will be looking into.
Do you feel that the system is being abused to protect certain people?
I knew that I was walking into public corruption, which again is why I ran. But I will tell you this, even I am shocked at the level of public corruption.
I am shocked at how deep it goes, and I am shocked at how powerful it is. I have never seen anything like this. It's breathtaking. It has been described by the people familiar with what is happening as shameful.